now.
Good evening. This is the June 18th, 2013 U.S. Constitution Meetup of the Austin Constitution Meetup Group. I'm Jon Roland, and this evening I'm going to be discussing several current topics of interest. I appreciate if you hold off on the questions until I finished, so that we can treat them separately in the recording session. Now, the first topic is defects in the Constitution. The framers of the Constitution got so much right that we are inclined to overlook sometimes the things that they overlooked. But it didn't take very long for some of the things they overlooked to have become a problem. And they remain, in many cases, a problem to this day. They haven't all been addressed with amendments. So, do a page down to get the next one. Okay, there we go. One of the first defects that I'm going to discuss this evening is omission of authority to prosecute what were then regarded as common law crimes. Now, common law crimes were the kind of crimes that were the subject of most court action on criminal action in England and the American colonies at the time of the Revolution. They were not defined by statute. They included things like murder, theft, robbery, rape, trespass, assault, fraud, perjury, a host of other things that for which we now have statutes, criminal statutes, but which at the time were created only by court precedents. Now, the question arose shortly after the Constitution was adopted whether there was authority to prosecute common law crimes. And it seems apparent at this time, looking at the Constitution, the way it was written, the way it was debated, that it seems likely that many of the framers thought that there would be authority to prosecute common law crimes, so they didn't mention or provide for specific authority to do so. On the other hand, as obviously some of the other framers thought there would not be such authority. And apparently neither side brought the issue to the attention of the other because they didn't include any provisions in the Constitution to deal with the question. You have things like the trial of all crimes, as though they were expecting to have a lot of them. But in the Kentucky resolutions of 1798, written by Thomas Jefferson, he pointed out that under the Constitution, Congress was authorized only to prosecute for treason, counterfeiting, piracy and felonies on the high seas, and offenses against the laws of nations. That's a substantial list of crimes, but it's not a whole bunch of them. And they didn't come up that often. So the question naturally arises when they wrote a phrase like removal from office for treason, bribery, and other high crimes and misdemeanors. They later provided for punishment for treason in the sense of defining it and authorizing punishment of it, but they didn't mention bribery or high crimes and misdemeanors. So there was no congressional authority granted to criminally prosecute those things as crimes. But why did they mention them if they didn't expect Congress to have the authority to pass statutes to punish them? Did they expect that any punishment would be done by the states? What about the territories? So obviously they didn't give much attention to this subject, but it came up in first of all in 1798 with the Alien and Sedition Acts, which Jefferson and Madison and the other founders, who might classify as Whigs, to use the English term. In English law or politics, people divided between Whigs and Tories. The Whigs were what we would today call libertarians, and the Tories were more likely what we today call big government conservatives. The Jefferson at that point led a party of what came to be called Republicans, and his opponents called themselves Federalists. So the labels could change, but the concept remained the same. Well, the Federalists were in favor of the federal government having authority to prosecute common law crimes. And the Republicans generally were not. But then some Jefferson-appointed Republicans in Connecticut prosecuted the editors of a newspaper named Hudson and Goodwin for publishing a false article that Jefferson had illegally transferred $2 million to France for the purchase of Western Florida, which was then owned by Spain. Well, there was a secret session of Congress to authorize the $2 million for a negotiation through France with Spain, which ultimately didn't lead to anything. There was no money transferred. But so the Quran got it wrong, but the Jefferson supporters thought that that was constituting criminal libel, so they tried to prosecute for it. And since there was no statute making libel a crime, it had to be prosecuted as a common law crime, which it could have been in England. Well, the defense argued that there were no common law crimes under the U.S. Constitution, which was a Whig argument. Well, it took until 1812 for the case to finally make it to the Supreme Court, by which time most interest in it had been lost. The prosecutors didn't even show up, and the prevailing argument was essentially a Jeffersonian one, although not prosecuted originally by Jeffersonians, that there were no common law crimes. And that was a case of United States versus Hudson and Goodwin, which is discussed on my website, constitution.org. Now, what's interesting about that is that it created a vast area of non-authority on the part of the federal government, which it has been trying to fill in ever since with what amount to usurpations. some of which are, to do things that are arguably needed, but with which it does not have authority, and others of which are it's clearly beyond its authority and should be. Now, much, for example, of what's done with the Commerce and Necessary and Proper Clause is essentially to deal with the lack of authority to prosecute many kinds of crimes. For example, there is no authority to prosecute for the crime of failing to obey a court order, or even to enforce a court order. That's kind of an important omission. Well, they just gloss over it and say, well, that's an inherent power of the court. Well, it might be an inherent power of the court, but it's not an inherent power of Congress or the executive branch. So, the problem then really needs to be addressed with a new set of amendments, which I have proposed under my draft amendments in the second section on remedial amendments. The first section is on clarifying amendments. That's clarifying the language of existing provisions to make them less ambiguous. The second section is on remedial amendments. That's to remedy defects that were essentially oversights. And then the third are substantive amendments, things that we really should be able to do and for which there's no authority, even though in many cases we're doing it anyway. The second major defect is the omission of a longer list of rights than those specified in Article 1 to 8 of the Bill of Rights. Jefferson and the others simply lumped the others into the Ninth Amendment. But that has proven not to be adequate because nobody, no modern lawyer or judge, seems to be willing to go back into history and find out what those other unenumerated rights are. They are, in fact, they're downright resistant to it. So they really need to be spelled out. And I have proposed legislation that would spell it out as an amendment to the Civil Rights Act, for simply listing them all. It runs us many pages. And it doesn't claim to cover all rights, but it covers so many that, what's left is pretty obscure. Now, the third major defect is a failure to provide that the rights in the Bill of Rights apply to the states, even if federal courts don't have jurisdiction over them. Now that was presumed at the time. Most states had their own Bill of Rights, so they thought, well, the states have it covered. But in fact, the states didn't have it covered. And that still would leave the question whether putting the Bill of Rights in the federal Constitution made them federal questions that would confer jurisdiction on federal courts to adjudicate cases between a citizen and his own state. That was the issue in Barron v. Baltimore, in which a individual who had a wharf adjacent to the city of Baltimore, and as a result of dredging projects by the city, it rendered his wharf useless. He essentially landlocked it. So he sued for damages, claiming that Baltimore had deprived him of property without due process. And the holding by Chief Justice John Marshall was that the Bill of Rights did not apply to the states, or more precisely, that the federal courts did not have jurisdiction to adjudicate such cases. Now, what was really going on there is that it was recognized, that it emerged from the case, that if the Bill of Rights were to apply, particularly the Fifth Amendment, to the states, and it includes the clause, no person shall be denied life, liberty, or property without due process of law. And if blacks were persons, and they were considered persons, then that would essentially rule out slavery. And Marshall and the others apparently thought that if they were to come down on the other side, that they would be laying the basis for declaring slavery unconstitutional, and that would trigger a civil war. So it was a political decision, not a principled position based upon the actual text of the Constitution or the logic of it. But the 14th Amendment was intended to overturn Barron v. Baltimore and also Dred Scott v. Sanford, those two cases primarily. And it was felt necessary to adopt an amendment because by that point, those cases had become so entrenched with further precedents built upon them that the only way to unravel those precedents was to adopt an amendment, which is why I propose so many amendments. Because at this point, the only way to unravel all the bad court precedents is to amend them into a state of which they were, what the jurisprudence was before the first such precedents were established. Now, next would be a failure to provide authority to break up excessive concentrations of private power. There is actually no authority for the Antitrust Act to break up monopolies and things of that sort. That was argued to be under an implied power of the Commerce Clause, but that doesn't really work. That the most that could be done would be to create a civil jurisdiction for private parties to sue large organizations and seek breakup as a remedy. But it would not authorize the government to appear as a party. So it's especially not to provide for criminal penalties. So large organizations, large banks, holding companies, labor unions, monopolies, whatever, are essentially beyond the reach of law under the Constitution as it was originally written. Now, next would be failure to specify standards for trial and grand juries. The framers simply used the term trial, jury or grand jury, and assumed that everybody would know what they meant by that. But they didn't anticipate that later generations would try to define those things out of existence, especially at the state level. And by cleverly manipulating process and structure, reduced them to a much less effective level. So what are needed there are for the standards to be made clear and made specific. And on my website, Constitution.org, I have that laid out. Next was a failure to protect private prosecutions of public rights, such as quo warranto and habeas corpus. Habeas corpus lingers on, but it's been changed from something that it can be done without the help of a court to something that requires court approval. You apply for a writ of habeas corpus now. Originally, you just filed a writ of habeas corpus, and the court didn't have to accept it as an application. It was not some kind of petition. And these were the tools that enabled private citizens to hold government accountable. And without them, government cannot essentially not be held accountable. Next was the failure to require common law rules of construction, specifically the presumption of non-authority. That was presumed at the time, but it has to be spelled out. Because I encounter in debates all the time with lawyers, including law professors, that they're asking me to prove that delegations of power are supposed to be interpreted strictly. They say, well, why can't they be interpreted broadly and rights narrowly? Who says that powers may only be interpreted strictly? Well, it was assumed at the time that that was the way things worked. But you can't assume that. You have to make it explicit. There's a failure to forbid binding stare decisis. It was assumed that court decisions would apply only to the parties to the case, and that precedent would at most be advisory, suggested, never binding. And yet, through practice, it has become binding. And that is a threat to the Constitution itself, because it allows binding precedents to be given more weight than the Constitution. Finally, there's a failure to provide authority to enforce court orders. They do it anyway, but the authority is missing, which I mentioned earlier. So, I mentioned earlier common law crimes. This just summarizes them. The basic problem with common law crimes is they are defined at trial, not before the act is committed. And therefore, they are inherently ex post facto. And the Constitution prohibits ex post facto laws, both for the federal government and for the states. So because it does, it essentially prohibits common law crimes, both for the federal government and for the states, except that in some states they still try to prosecute common law crimes at the state level.